it tomorrow.
Good afternoon and welcome to the Appellate Division First Department. Most of you know the drill. I will begin by calling the call of the calendar and asking you to give me your requested argument time. I'm going to let you know that we have over 6 hours of requested argument time today. And I can assure you that the attorneys at the end of the calendar don't want to be here till 11 o'clock. So please give me the time you need, not the time that you want, understanding that the court is familiar with the briefs and the record, oftentimes more than you wish we were. And if you are brilliant in your argument, understand that the time is for you, not for the court. So if your arguments are so interesting and biting that my colleagues continue to ask questions, I will allow them to, okay? That being said, let's begin. People versus Stephen Wilson. How much? 1 minute for rebuttal. At 3 and 1, okay. 3 and 1 and 3, thank you. Cy versus JCHHB Inc. Okay.
We'd have to maybe allow 5 minutes for each one.
Okay. All right. 3 and 2 and 5. M. Hazel Selena is submitted. U.S. Bank versus Bergen.
Appellant 6 and 2 for me.
Okay.
Respondent 5.
6 and 1 and 5. Moore Street Building versus Abbott Resource.
Appellant 5 and 1, please.
Okay.
Respondent 6, Your Honor.
5 and 1 and 6. People versus Sebastian Salazar. Submitted. Patrick versus 278 8th Associates. Okay. Okay. 5 and 1, 3 and 1, and 5 and 1. W54-7 versus Rooney.
7 minutes and 2-minute rebuttal for the appellant.
Okay.
6 minutes for the respondent.
All right, gentlemen, 5 and 1 and 5. Board of Managers versus Curtin.
For appellant, Your Honor, 7 and 2, please.
For the respondent, 5 minutes, Your Honor.
5 and 1 and 5. B. Michael versus Patricia S. Submitted. 2M Hospitality versus Sahara Plaza.
For the appellant, 6 and 2, Your Honor. For the respondent, 5 minutes.
5 and 1 and 5. Canner versus Westchester Medical.
Good afternoon. 6 and 2 for the appellant.
Okay. 5 and 1 and 5. A&A Management versus Kasadov et al.
For the appellant, Your Honor, 4 and 2, please.
Okay.
Respondent 5.
4 and 2 and 5. People versus Tyrone Gines. Okay. 3 and 2 and 3. Herman versus Herman.
5 and 2
Correspondent 7.
3 and 1 and 4. This is not your first appeal. Okay, first case on the calendar, People versus Stephen Wilson. You may proceed.
Good afternoon, Your Honors. Mary Catherine Smith from the Legal Aid Society on behalf of Stephen Wilson. Mr. Wilson is before this court today requesting a sentence reduction from the maximum term of 5 years post-release supervision to 2.5 years post-release supervision. Mr. Wilson's youth at the time of this offense is a compelling mitigating factor in this case. He was 21 years old in 2017. Social research demonstrates that when someone is 21 years old, they're still in the midst of crucial brain development in maturity, ability to resist impulses, and peer influence. And some of this court's decisions have reflected that by seeing youth as a compelling mitigating factor.
So I'm very sympathetic to the argument that young people's brains are not fully formed, but I have trouble believing that at the age of 21, he wouldn't understand that firing 15 shots on a sidewalk at people less than half a block away could cause very serious damage. So even if his brain wasn't fully developed, I would have thought that would have been something he would understand. Could you address that?
Yes, Your Honor, I think that point is fairly taken. And I think what youth provides is not always a justification for an offense, but important context to understand the person who committed it and how they've changed since then. When someone is young, when they are in the midst of development, in the full swing of peer influence, how they think about those types of decisions.
Yes, but he already had gotten a pretty lenient sentence in New Jersey for his conspiracy conviction in New Jersey. So you would think that if he had gotten a break in 2015, that he would have learned from that and not taken a firearm and shot recklessly into a crowd of people.
Yes, Your Honor. He did have a prior conviction in New Jersey for conspiracy fencing, the sale of stolen goods, and he did receive a probationary sentence for that, but he was 18 at that time. This was 3 years before this crime happened. And respectfully, I think that the record indicates that he shot at 2 people, not a crowd. And while that is still...
You're requesting that the post-release supervision be reduced, but doesn't the less is more statute accommodate that? And if he does well, he can apply through that?
Yes, Your Honor is correct that less is more allows for administrative reduction of post-release supervision. And we would submit that less is more reflects an understanding by the legislature that excessive terms of post-release supervision are counterproductive. They stretch state
Well, that's why the
resources.
statute's there, so your client can avail himself of the statutory relief.
Yes, Your Honor, my client can avail himself of that statutory relief. It has been over a year, and he has not reoffended. He's doing great on post-release supervision, and the sentence is still ultimately excessive. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the court, Christian Rose for the people. This court should not reduce defendant's post-release supervision term after he and a co-defendant on a public sidewalk fired 15 times at 2 people. I would just point out that this court affirmed the co-defendant's identical sentence, and comparing the briefs in those cases show how similar they were situated, including that they were both 21 years of age at the time of the offense. If you have no other questions, we ask that Your Honors affirm.
Thank you. Counsel?
Your Honor, DeVay Harrison's sentence is not before the court in this case. What is before the court is Stephen Wilson's.
Isn't that, we're still allowed to consider that, aren't we?
I think so, but I apologize, Your Honor. I didn't understand that briefs from the co-defendant's case could come in as the record here, nor has the district attorney's office disclosed.
Not so much briefs, but certainly it is fair argument to say that the co-defendants were treated similarly. There's nothing wrong with that. And in fact, some of your colleagues will often argue, my client got hit a lot harder than the co-defendant, et cetera, et cetera. So we hear arguments like this all the time.
Yes.
But you may continue.
Yes, Your Honor. And while proportionality did happen here, Mr. Stephen Wilson is also a high school graduate. He has strong family support. Both parents live in New Jersey. He has
That didn't prevent him from engaging in this conduct at the time, right?
Yes, Your Honor, but this court has considered family ties and support to be a mitigating factor, even when those ties and supports existed at the time of the crime.
Thank you.
Thank you.
Tsai versus JCHHB, Inc. You may proceed.
Good afternoon, Your Honors. As the court below found, the facts are not disputed in this case. The reason I only requested 3 minutes is because there is not a single factual issue. The only question before the court is whether or not the court below properly applied the Court of Appeals holding in the Chazen case to the facts here.
Isn't, in understanding the posture taken by the proprietary lessee who sublet here, you started the action seeking rent and use and occupancy and attorney's fees, the first 3 causes of action. Then you amended the complaint for ejectment based on the termination. The action was started before the termination because you had to give 90 days pursuant to the
Correct.
the law, correct?
Correct, Your Honor.
So again, that's not disputed.
No.
Now, as we sit here today, your brief suggested there was error in not focusing on the ejectment alone, but you didn't withdraw the first 3 causes of action here, did you? I didn't see that in the record.
No, Your Honor, but if you look at the defendant's 10th affirmative defense, which is record page 59, paragraph 64, they didn't ask for dismissal of the ejectment cause of action. And if you compare that to the 3rd decretal paragraph, record page 7 of the court below's order, she granted relief that was never requested. They understood that dismissal of an ejectment action was not a proper remedy under the undisputed facts. The court simply made a mistake. Chazen does not support dismissal of the ejectment cause of action, which was based solely upon the expiration of the lease. Had nothing to do with money. We concur that the court below got it right on dismissing the first 2 causes of action, but just made an oversight on the remaining cause of action. Are there any questions? Thank you, Your Honors.
Thank you.
May it please the court. My name is Serge Joseph, and I represent defendant, respondent's tenant in this appeal. This court should affirm Supreme Court's well-reasoned order. Supreme Court properly found that the true nature of the case was one seeking possession based upon tenant's alleged failure to pay rent, and that this was barred by multiple dwelling law section 302B3. Landlord made the failure to pay rent front and center of her case in the underlying proceeding. It was not merely that landlord initially commenced, as Justice Schulman noted, the case below in May of 2023, alleging in her complaint 3 causes of action, all related to failure to pay rent. Landlord sought rent in the first 2 causes of action, and landlord sought attorney's fees based upon default in the payment of rent.
Don't they have a cause of action for ejectment based on the expiration of the lease?
But Your Honor, I would note that it is absolutely, regardless of how a pleading is styled, the ultimate responsibility in the first instance to ascertain the true nature of the case lies with the court. And what the court did below was find that the true nature.
Is there anything stopping them from bringing a separate cause of action or a separate action solely for ejectment based on the expiration of the lease?
They certainly can do that, Your Honor, except.
What's the difference? They amended it to go after that claim as well.
Except, Your Honor, immediately after starting the case, they brought an order to show cause seeking rent pendolente from
There's
June
no doubt that
2023.
they were seeking rent. That's not in doubt. But the question is, what stops them from adding this cause of action now to seek ejectment based on the end of the lease?
I would also note, Your Honor, the lease itself in paragraph 50 says that the landlord can terminate the tenancy in the event of the tenant's failure to pay rent, particularly where the issue of the certificate of occupancy is raised. And that's exactly what they did in this case. Once the tenant stopped paying rent, they commenced the action below. And the court below, in its discretion, found that the true nature of the case was one seeking possession based on failure to pay rent. I just want to
But counsel,
very
do you
briefly.
concede that they can commence a new action where the true nature of the case is ejectment based on the expiration of the lease?
Well, Your Honor, that's not what's before us. Yes, Your Honor, theoretically, if they, at a subsequent date, commence an action solely seeking ejectment, that would be a different issue. But that's not what happened in this case. What happened in this case was they commenced first an action seeking rent. They aggressively pursued relief for rent. And the court properly found, based upon its reading of the complaint and all the attendant circumstances, including that even after the expiration of the termination notice, they sought rent. So given all of these, Your Honor, I think the court below acted properly in finding that the true nature of the case was one seeking possession based on rent. I would note, Your Honor, that there is an issue of retaliatory eviction, and I'm not sure how much time I have.
About a minute and 15
So I'm going to go
seconds.
very fast. In essence, a landlord argues that retaliatory eviction claim under 223B does not apply because the certificate of occupancy is one for commercial and not residential. Clearly, that's a meritless argument. What the court determines is not what the CFO says, but the actual use. And there's no dispute that the actual use, what the parties intended, was residential. Paragraph 1 of the lease says that. Paragraph 1 of the lease says that it is to be used for residential purposes. So clearly, 223 applies. And there's one other issue that I very briefly, Your Honor, there is some argument that the tenant only raised an issue as to lack of heat in 2022. That's clearly not the case. If Your Honors look at the record, you'll see that the email that the landlord itself focuses on raises four substantive issues, including the rent that the landlord was seeking was too high, including that the fact that the landlord took away a substantial portion of the subject apartment. So clearly, a tenant made a showing for retaliatory eviction. Thank you, Your Honor. Thank you for your patience.
You have 2 minutes.
Thank you, Your Honor. Briefly, that's a complete mischaracterization of the cause of action for ejectment. I invite the court to look at the cause of action for ejectment and see. There's no mention of money anywhere. The court below did not characterize this one as essentially for money. Those words appear nowhere in it. And virtually every case that respondents rely upon involve two essential points that are not involved in this case. Number one, they involve a loft
Is it fatal
tenant.
that you amended your complaint to add that cause of action as opposed to bringing a new action?
Why would we split a cause of action? We had jurisdiction. Everybody was there. It's part and parcel of the same thing. We couldn't bring the ejectment caution action any earlier because of the requirement of serving a 90-day notice.
You would do that to make it clear so that it wouldn't look as though the true nature of the claim is for payment of rent.
Well, the true nature, if we believe everything that respondent says in their brief, is that this premises cannot be used for residential purposes. It's illegal. So the question I was hoping you to ask him is, how can his client continue in possession when the court below found it may not be utilized for residential purposes?
While there are cases,
The question that raises is why your client rented it to them for that purpose.
I wish I could answer that, Your Honor. That's a great
It
question.
seems to me that's a question we have a right to ask.
Apparently, no one in this co-op is aware of the fact that there's no residential C of O for the building. I don't represent the co-op. I only represent this proprietary lessee. But that's clearly what happened here. They never got their residential certificate of occupancy. So the sublease expired, the corporate tenant remained in possession, and after we started an action for rent, and the notice expired, we amended the complaint to include an ejectment cause of action.
Well, there are cases that talk about voluntary, volitional illegality in addressing that issue, but then you're not seeking rent, right?
It's expedient to amend rather than commence a separate action and then move to consolidate. the two
Just
cases.
humor me, I'm just
Yes, sir.
curious. When I started reading this, I was thinking loft law. There was no application for an interim multiple. This is not an IDM building of any kind.
This is not. This is a full-blown co-op.
So they rented residential in a fully commercial building.
It says light manufacturing and office use. That's what the C of O says.
In other words, not residential.
Correct, Your Honor.
And your client created a lease
Well, my
for
client's-
what he knew he could not do.
No, she was not aware that there was no certificate of
Oh,
occupancy.
she knew. Thank you.
Thank you, Your Honor.
U.S. Bank versus Bergen. You may proceed.
Good afternoon, Your Honors. Brian Grafman, Bora Goldstein for Teresa Bergen. This is the abusive residential foreclosure case, a case in equity. Ms. Bergen, a disabled senior, lives in the premises where she's lived her whole life, now with her daughter. The bank refused her partial payments, and it's in the briefs what the bank did to this poor woman. There are so many wrongful acts that
Counsel,
in my
Counsel,
Oh, yes,
I'm very sympathetic to the concerns you're raising, but I'm a little troubled by how we can do anything about it, especially given the motion, the second motion for summary judgment, which she failed to respond to, the April 14th, 22, no, I'm sorry.
Yes,
The
default.
second round of motion for summary judgment, where she again didn't respond. I'm having trouble understanding how we can get around that. That's one question. My second question is whether any proceedings have been brought against any of the prior attorneys or any complaints have been made against any of the prior attorneys.
Okay, to answer the first question, on the default by Ms. Bergen's prior attorney, first of all, she had no idea of that at the time, of course. And this court has discretion, we cite the cases, to vacate a default to remedy egregious misconduct.
I'm not talking about the first one, I'm talking about the failure to object to this on the second round, the second summary judgment motion.
No opposition, I think that's the word.
Right.
You mean the grounds on the summary judgment motion?
There was no opposition.
No opposition filed.
Right, well, that was a default. Well, okay, on the default, what we say in these cases is, there is this, so let me just address this. It's in the briefs that, which we cite the European American Bank case and the Embanique Capital Corp case. The court has discretion to remedy a default, to remedy egregious misconduct.
Counsel, the attorney knew that there was a summary judgment motion. The attorney knew they were supposed to respond to that motion and submit opposition. The attorney's excuse for not doing so is, we were in negotiation.
Correct.
Tell me where in the CPLR it says you don't have to respond to a summary judgment motion because I'm in the middle of negotiations. None, right? The answer is there is no such section.
Right, but there was a
So
section.
explain to me, which is what my colleague was trying to ask you, how do we get past a intentional default? Because they knew.
Okay, well, and I will respond to that. What he says, and this sort of comports what you said, I reasonably relied on their good faith and that they were going to act in good faith, as Judge Moulton says in his cases, they have an obligation to do so.
Why was
and
that
it's-
reasonable reliance? If you want to rely on negotiations, then you get a stip from the other side saying, in reliance on the other negotiations, then my time to respond is delayed until
I
whenever.
understand. And
Well,
what
I don't
happened
understand
is-
what's reasonable about the reliance.
Well, because in this case, he's representing somebody who's not really that moneyed a person, and there was so much misconduct on the other side that he's fighting by having to submit application after application after application, getting crazy denials. The attorney's saying.
So you know what it sounds like you just said? It sounds like you just said he didn't respond because the client didn't have money to pay him.
No,
that's what it sounds like.
That's not the sole thing. It's the
well, then
fact-
don't say that.
Okay, then I
Because he has an ethical obligation to respond to a motion,
Of course.
a substantive motion at that.
I understand, yes, of course. It was somewhat overwhelming for him. I wasn't the attorney, but poor Miss Bergen is sitting there. She has no idea about this happening. And, they say, well, you're stuck with the acts of your attorney, but when her attorney came in and said, hey, by the way, you're sending these to the wrong address, she doesn't even, the mortgage says this. They didn't want to hear from that attorney, and they kept sending it to the wrong address. 8 times, my chart is wrong. I have 5 times there. I could add the 3 more. 8 times they sent it to the wrong address. So here they're saying the attorney screwed up, but on the other hand, they don't want to listen to the attorney when he tells them what to do. They were overwhelmed. That's the reality of it, the way I could figure it. Certainly, I would have gotten another extension, and certainly I would have answered the summary judgment motion somehow, but somehow it didn't happen. Meantime, she lives in this building. There are obviously the denials of all those applications are clearly.
Can you explain to me why, if the plaintiff here had such a significant source of income, as is indicated by the record, she fails to make any mortgage payments
Well, they wouldn't accept
since 2014?
Yeah, that's in the record at page 1212. She tried and they wouldn't take it. She came to them after 2008 when things hit and she got disabled. She said, I would like to rework something. They wouldn't do it. She paid for another 2 years. Then she had a little bit of a default, and Hurricane Irene, and she used a mortgage, by the way, to fix the premises. It's all in the record. It's on my first few pages of my brief. Hurricane Irene hits. She corrects stuff from that. And meantime, they're just it's a very abusive situation where they say, yeah, come apply. She pays the attorney to apply. She has a big application. Some of them seem like 100 pages in the record. And then they just deny it for a ridiculous reason. No income. The judge even had an order that said she has income. Still no income. And they said, we're going to review it as a single-family residence. That's in the record also. And then they ignore all that.
All right.
And then they deny it eventually.
You'll have time on rebuttal.
Thank you.
May it please the court, Harold Kaufman, McCalla, Raymer, Weber, Pierce, LLC, on behalf of plaintiff respondent. I want to focus on the point that the court was raising, which is the order of reference motion, which was not opposed. We consented to 4 stipulations. The 4th stipulation, which is in the record at 284, said final adjournment. Despite that, defendant's counsel did not oppose. There is no basis.
Counsel, there is no question that this case has a tortured set of facts where the bank repeatedly messed up big. They continually made erroneous decisions on her applications, which delayed this case by at least a year and a half. First, there was the constant improper designation of this property as commercial instead of residential, right? And her application was denied at least 4 times on that basis. And now you want to use the excuse of delay that your client is partly responsible for as the reason why she should not have gotten a modification.
Well,
How is that fair?
we're not here to determine whether she should have gotten a modification. In fact, there's no basis in the record to say that she should have gotten a modification. And to the extent that there was any delay,
All of the basis for denying the modification were in error.
that has not been established.
Oh, I think it has been
First,
established.
no, it hasn't. There is not any finding that she was denied based on the income. The property was
Your
listed
documents say that she was denied because your records showed that she had 0 income. That's completely
That is not what those letters do not say that. They do identify, some of them, that there was 0 income, but they said she failed to meet delinquency requirements. There is no testimony or no evidence in the record that they improperly denied it. However, even assuming
You
that
acknowledge
they did,
that your letters to her said she had zero income.
they did say that.
Which is
However,
false.
that has nothing to do with whether or not the foreclosure judgment should have been vacated.
It has everything to do with whether a modification would be granted, because clearly a bank would not give a modification of a loan for someone with zero income.
None of her defenses, none of her excuses go to the fact that she didn't file opposition to the order of reference, and her opposition, the court exercised its discretion and did not vacate the decisions that were made on the JFS. Those were all proper decisions. Her new evidence was old evidence. To the extent that she has claims, she has a claim against her prior attorney for malpractice, for not opposing, but there's no evidence that she had any defenses in that. She has a potential claim against the mortgage loan servicer under RESPA, but the mortgage loan servicer is not a party in this action. She has no defenses to the JFS that was entered under any of the theories that she raises, including 3408, which does not provide her the basis to dismiss. This took place 5 years after the 3408. To the extent she wants to make a RESPA claim, we can deal with that, but that has nothing to do with this foreclosure action. If the court doesn't have any more questions, I will rest.
Okay.
Thank you.
Just real briefly, if I may. First of all, on the zero incomes, it says right on it, the basis of the determination was zero income. It says the basis, that's what it says. Secondly, in their brief at page 25, they suggest Ms. Bergen would only have a case if there were inconsistent or contradictory communications or piecemeal document requests, which is this case exactly. And on the denials of the modifications, there was no determination, there's nothing in the record saying that there were proper denials.
Exactly.
They haven't given a proper basis for any dispute on that. Thank you very much. What the court should do, I'm sorry, the court should send a message and you dismiss this case because
You should never make that argument.
okay, or
Because it is not our job to send a message.
send it back, no, pull that back. Send it back for, attorney fees should be split, sent, ask for, they should be reimbursing her attorney's fees for all of the, what they put her through to have to pay attorneys. Thank you very much.
Thank you. Moore Street Building versus Abbott Resource.
Good afternoon, Your Honors. May it please the court, David Kaminsky for the appellant Abbott. The underlying dispute involves a joint venture agreement about a loft building in Tribeca. My client took assignments of 2 mortgages that were on the property in 1998. The mortgages weren't getting paid.
Mr. Kaminsky, this appeal, really, one of the central issues here was your client's default. And
Yes.
for the life of me, I mean, that's what I found just eye-opening, that Ms. Davidson trumped up this whole excuse in not being able to go to trial, which would have allowed her to submit anything to the plaintiff's case.
Yes, you're right, Judge. That's the issue. But there's nothing trumped up. My client at the time was an 81-year-old lady who was trying her best to get to the trial.
But the evidence in the record is that there are flights that she could have gotten on and she didn't.
And she never showed up, not in the many days that the trial was ongoing for.
And you're not claiming certainly that there were no flights that whole time.
There were no flights that whole time. There's no
Counsel, please.
There's no proof that there were flights available to her. She made it all the way to Miami. There were
Counsel, when
1,000
your
flights
client
in.
says, there were no flights, and so I could not get to the trial that I was required to be at, it is on you to provide that proof.
Well, the
You
record
don't have to,
exists.
they don't have to prove the negative. You have to prove the excuse you are asserting in order to not be in default?
Well, she spoke on the phone to Judge Perry, Phaedra Perry, and explained the circumstances.
I'm sorry,
that
she had an
her-
ex parte communication?
I'm sorry?
Are you saying your client had an ex parte communication with the judge?
No, of course not. The Judge Phaedra Perry called my client on the phone from the courtroom with the counsel being there. So it was not ex parte.
So what does that mean, though? What happened in the conversation, other than the judge telling her, you need to get here?
Well, she was trying to get there.
Well, no, what happened was that she thought she was getting a one-week adjournment when her attorney couldn't get it for her because the judge wanted to move forward. She fired her attorney that day. So there was this constant issue of whether he could say or do anything on her behalf since she fired him that day, and she tried to use that discharge to buy more time. And the court had this conversation with all counsel present to try and resolve it and said, okay, I'll give you time to get here. The judge actually gave Ms. Davidson at least a few days to try and get to New York, and she just never showed up.
Not a few days, Judge. She said, come tomorrow, okay? This is an 81-year-old lady who was in Bahamas.
You know, with all due
Who was
respect,
struggling to get
81-year-old
there.
people get on planes every day of the week, all the way around the world.
You're right, Judge.
Okay?
She was a sophisticated 81-year-old that entered into a joint venture agreement. So, counsel, succinctly, what is the reasonable excuse for the default?
Well, first of all, Judge, my client never terminated her counsel. There's no unequivocal, clear statement on the record that she fired her counsel, and a review of the record shows a very confusing back and forth.
Wasn't confusing to me. It was very clear.
Well, all right, Judge. The closest that it came to a termination was when Judge Phaedra Perry said, as far as your attorneys, do you want them to represent you? Davison said no, okay? But in all fairness, that's not an attorney. That's a person who doesn't know the import of her statement. And even after she said that no, Judge Perry said why? And she said, because they haven't been able to get me a continuance. And then Judge Perry still proceeded that the attorneys are still your attorneys. And
So
she
the
said,
no
"They're not
is not clear?
magicians."
Her
No,
answer of
it's
no
not
is
clear.
ambiguous?
I'll explain why. If I have a job, which I do, and someone said, do you want to keep your job? And I say no. Maybe I don't like my job. If I'm married and someone says, do you want to stay married? And I say no. It's not the same thing as quitting my job. It's not the same as putting in my letter of
But it's
resignation.
also a different thing if a judge in the middle of a trial says to you, do you want to get rid of your lawyer, or whether you say it to a friend in passing. She was being asked by the judge in the case whether she wanted to get rid of her lawyer, and therefore that statement had greater meaning than it would be if she said it in passing to someone else. And I think you're also leaving out the fact that this is not an unsophisticated person, but a person who is sophisticated enough to be brought on in a joint venture to convert a building to cooperative ownership. So you can't really have it both ways.
Well,
You'll have time on rebuttal.
thank you, Judge.
May it please the court, my name is Evan Mandel and I represent the respondent. I think the court understands the case. There are a couple of misstatements that were made that I'd just like to correct, and then I'll take any questions that the court has. First, my brother said that Judge Perry only gave Ms. Davison 1 day to appear at the trial. That is demonstrably false. Abbott requested a 5-business-day adjournment. She was given 4 business days to appear at the trial, and she did not do so voluntarily, as Justice Perry found. Second, my brother said that there were no flights available to Ms. Davison. That is demonstrably false. In fact, it's inconsistent with what Abbott represented to not 1, but 2 judges below. Abbott told both, there was the flight on the 9th, which is the day before the trial, where she has some story where she went to the Bahamas and flew to Florida and then decided to fly back to the Bahamas for reasons that are known only to her. And then on the Monday, she told both Judge Silvera and Justice Perry, I have booked another flight on the Monday, And they showed me a confirmation on their phone. It was a flight through RDU. I said, why did you go through RDU? They said she's only willing to fly first class. They promised Judge Silvera she would be there that day. Later that day, they claimed for the first time that while she had booked a flight that day, it was canceled. They never provided a confirmation. I asked them repeatedly to provide me the confirmation. They refused to do so. And then after the trial, Ms. Davison submits an affidavit that says she was unable to get any flight whatsoever on the 10th. She just pretended that she had never told two judges that she had a flight on the 10th. And those were the two misstatements I wanted to correct. And other than that, I'll take any questions.
Was there any equivocation about her discharge? My understanding from the record is that she clearly discharged her attorney, correct?
Correct. There were, on 17 occasions, her lawyers and her confirmed on the record that she wanted to discharge her lawyer. Those are
In fact, the
pages
lawyer
21.
refused to proceed because he had been discharged, correct?
That's correct. And those 17 instances are on page 21 through 23 of the brief. I'm happy to read those, but I think the court understands those.
And the other little tidbit that was left out of this argument is that she continually said that her judge friend told her that she should discharge her lawyer in order to get this continuance.
That's exactly right, Your Honor.
Thank you.
Thank you.
Your Honors, I'd like to add that it was eminently unfair for Judge Phaedra Perry to be asking questions about the attorney-client relationship that Ms. Davison had in front of opposing counsel.
Which questions are you claiming were unfair?
Do you want to discharge your attorney? Why do you want to discharge your attorney? These are attorney-client
I'm sorry,
privilege issues.
If a litigant raises the issue of firing his or her lawyer in the middle of trial, it seems to me those are entirely appropriate questions for the judge to ask to know whether there's a valid reason for that and whether it's going to stick or whether it's going to be disclaimed once the judge rules on it.
Yes, in camera, without my client having to disclose or espouse statements in front of opposing counsel. This is what Judge Perry could have easily done. She could have said, let's do plaintiff's trial. It's not a jury trial. Come next week and you put on your trial.
Why would she have any reason to believe that your client would show up the next week?
She was saying...
And the court doesn't have an obligation to run its court based on the schedule of the litigants before it. If we were to do that, the entire system would come to a screeching halt. But we have your arguments. Thank you. People versus Sebastian Salazar.
It's submitted. It's submitted.
Oh, sorry. Patrick versus 278 8th Associates. You know, not a problem. Not a problem.
Judge, which party would you like to hear from first?
Who was the first to appeal?
I am.
You are? So you go first. You may proceed.
Thank you, Your Honor. May it please the court. Michael Prisco for the GAP.
Bring that, yeah, get in front of that mic.
Your Honor, this court should dismiss the third-party defendant's contractual indemnification claim for any of the three following reasons. Number one, there was no privity of contract between the GAP and a third-party defendant, or the indemnification clause, the express language, had a prompt notice requirement that the third-party defendants did not meet, or alternatively, the defect that is claimed to have caused the accident is latent in nature by the third-party defendant's own admission, and the lease expressly held that if a defect is latent, it is on the landlord to repair that defect, and there's no obligation for the GAP to indemnify the landlord for an act or omission.
I do recall seeing an expert affidavit that said even a layperson could walk through that room and know that there was a problem with that ceiling. So I don't know how latent this defect was, but you can continue.
Okay. I'd like to first address the no privity of contract between the GAP and a third-party defendant. The lease, the original lease from 2000, was between 278 Associates, which is a named party in the contract, in the action. As evidenced in the record and admitted by the third-party defendants, prior to 2016, the date of the accident, the lease was taken over by an entity, 278 8th Associates LLC. And there's a letter in the record at 985 where the GAP is extending the lease for a number of years, all done before the accident, within the letter noting that the party in this action, 278 8th Associates, is the predecessor in interest to the new landlord, 278 Associates LLC, that is not a party in the action.
I'm sorry, didn't Mr. Jack Jamal in a submission clear up that the way the 278 8th Avenue was sued was incorrect, that it's really kind of like a typo type of scenario, and that it, in fact, you're resting on a hyper technicality and there was privity of contract?
Mr. Jamal did try and clear that up. His affidavit is insufficient. What he tried to clear up in the lease, they used or in the caption, it was the number 8TH, and he was saying that's just an error or a typographical error in the caption. But he does not in the affidavit say that the lease was between 278 8th Associates LLC. That is a non-party in this action. He is merely saying that the reference in the caption of the misspelling of 278 Associates, he's just clarifying that. He's not showing their privity between a named party and the GAP. As is clear on the record, and the third-party defendant concedes, the landlord, the successor in interest to the entity that Mr. Jamel's trying to clear up, is 278 8th Associates LLC. That's why there's no privity. Alternatively, in the lease and in the indemnification clause, the third-party defendant, the landlord, had to provide prompt notice to the GAP if they wanted to be indemnified.
And that didn't happen here.
That definitely did not happen, Your Honor. Notice is, as conceded by third-party defendants, was given to the GAP 3 weeks after they did their inspection in October 24, 2018, which is approximately a year and 4 months after the plaintiff commenced suit. That is not prompt notice under any reasonable standard. GAP was deprived of their express opportunity to investigate the action from the beginning, as is expressly stated in the lease. The prompt notice requirement, the second sentence after that, is talking about it would give the indemnitor a reasonable opportunity to maybe pick up the case from the beginning and not incur legal fees that they would have to reimburse to the landlord should they choose to pick up at that point in time.
Got it. All right. You'll have time on rebuttal,
Okay, thank you, Your Honor.
because you got like 10 seconds left.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent appellant. On our appeal, our position is the trial court erred in dismissing the plaintiff's common law negligence case on the ground that there's no question of fact as to notice and creation. The lease, well, first of all, the testimony of plaintiff and Wynn, who's an employee of the GAP, said that Ms. Wynn actually testified that the holes and patches and were evident 2 years before the incident, and that all you had to do was look up and see it, which undermines any feasible argument that this was latent. In addition to the testimony, the lease is replete with instances and evidence where the landlord has responsibility to maintain and to repair the ceiling. Specifically, 13.1A2, it talks about structural portions, which is not really defined in the lease. But our position is that the lease at A5 expands the landlord's repair obligation because it talks about the landlord specifically at A5 being responsible for latent defects. It doesn't exclude latent defects in the ceiling. It just says responsible for latent defects. So the lease provides ample evidence of the landlord's responsibility to maintain and repair the lease, the premises, the ceiling. In addition to the lease, we have the photographs, which speak for itself at 608 of the record. I mean, they just show a decrepit ceiling with repair and holes. In addition to the photographs, we have a battle of the experts, which you pointed out, which Your Honor pointed out. And I think what's remarkable about the battle of the experts is the defendant's expert doesn't attribute the ceiling collapse to anything. He just says it must have been latent. He doesn't say why the ceiling fell. He doesn't address the testimony of plaintiff and Miss Wynn that shows that these defects or evidence of these defects were there for years. And the plaintiff's expert, if you shift, the plaintiff's expert addresses it, discusses why his opinion is that there was prior patchwork or prior repair that was done to the ceiling that compromised the structural integrity of the ceiling. He explains how it should have been done and how
Was there
it
a
looks.
reply to that?
I'm sorry?
Was there a
No.
reply expert brief to that opinion?
No, Mr. Shabansky did not respond to Mr. Faranek. And Mr. Faranek also talks about how this is not a latent defect and why. And Mr. Faranek also explains the method of patching that should have been done. So the battle of the expert should have defeated summary judgment. And one last thing before I sit is that the trial court's order is inherently inconsistent because in one breath, the court says that the landlord eliminated any issue of fact as creation and notice. And then when discussing res ipsa and when discussing the defendant's issues of indemnification and contribution, says at 19 of the record, there's an issue of fact as to whether the defendant owner and the gap at the defendant owner caused and created the ceiling defect. So in that regard, we believe the court erred. If you have no further questions, I'll come back and reply. Thank you.
Okay. Counsel, you have 3 minutes.
May it please the court, Rose Cotter for defendant respondent cross appellant 278 8th. At first, I'd like to reply to GAP's appeal. As to lack of privity, we submitted a very detailed affidavit from Jack Jamal, which essentially describes the 278 versus 278 mistake as a typo, and GAP should not be allowed to escape that on a technicality. There is clearly an issue of fact as to latent defect, just based upon the different opinions of experts here. So GAP's argument as to the landlord being responsible for latent defects is an issue of fact.
So what in your papers refuted plaintiff's experts' analysis of the problems with the ceiling?
I had my own expert that refuted it. Plaintiff's expert, and if you look at Judge Taylor's decision, went in a separate inspection years later and gave an opinion. I have my expert, Sherbansky, refutes his version in the record.
So you're not claiming that you put in a second affidavit to refute specifically what came from plaintiff?
Not a second one, no.
Okay.
Does your expert detail what actually caused the accident based on?
Well, he obviously wasn't there. We got in as soon as
Well, what
GAP
caused
gave us
the
access.
defect? Not the accident, what caused the defect?
He didn't find a defect. He found that it was a drop ceiling, which was the responsibility of the tenant, GAP. And from his review, it wouldn't have been something that would have been noticed by a person walking through. That was essentially his opinion. GAP did raise the issue of, delay in bringing them in. We had an inspection,
What about the notice requirement in the lease, especially given that you had the opportunity to go in with 2-day notice to the GAP to make any inspections that you needed to make?
Well, we did need GAP to let us in to the store.
You're the landlord.
Well, for the inspection, once it was in litigation, we did it through the attorneys. There was a letter early on before the inspection between the insurance carriers placing them on notice. But the inspection was October 2018. We implemented the GAP in November 2018 as soon as we had an expert in there that said it's definitely a dropped non-structural ceiling. So the ceiling itself was non-structural and the responsibility of the tenant.
But it wasn't the drop ceiling that hurt the plaintiff, it was the ceiling itself.
It was a drop ceiling, almost like that cardboard material that's kind of separate.
Yeah, but the foam boards that go into a drop ceiling are not going to render you unconscious.
Well, that's a medical argument, but that is what came apart, chunks of that cardboard drop ceiling. The lease put structural repairs on my client, so if it was a leak from the roof, for example, then it would be on my client. A drop ceiling, though, our argument against the gap is that that's non-structural, and if plaintiff's case is able to survive at all, we're looking for a pass-through to the gap. But if I may address plaintiff's arguments, only
I'll
because
give
of
you
time.
30 seconds, go ahead.
Plaintiff claims that there was notice. Judge Taylor got it right below that there was no notice. My client was completely out of possession. He physically was there, he said, once or twice a year. So unless notified of an issue in the basement with the ceiling, I'd have no reason to go. The court did err in allowing plaintiff's case to survive on exclusive control and determining that res ipsa would survive for a trial of this case. There's no indication that my client was in exclusive control of the drop ceiling in the basement. It was Gap, the tenant, who had exclusive control. And the case law is clear. You need all three elements for res ipsa locator to apply. Again, we were not on site, and this was a non-structural issue that was the responsibility of the tenant.
Thank you.
Thank you.
You have 1 minute.
Thank you, Your Honor. On the issue of prompt notice, there was no notice. There was no notice before.
I don't think that one is your weakest argument, but if you want to hit that again, go ahead.
There was no notice after they had the inspection in 2018. 3 weeks later, they provide the prompt notice. There's no evidence in the record that attorneys were contacted, and I just want to advise the court, in the record, it's the landlord. Of course, they had the right of reentry. On the record, on page 1003, 13.3 of the lease gives the landlord the right of reentry. They just had to give the Gap 2 days notice, and they could come in and inspect the basement. On the issue of privity, Your Honor raised the issue of Mr. Jamel's affidavit. The third-party defendant, in their brief, admits that 278 Associates, where the entity is a New York partnership, not a limited liability corporation, that's the entity they say is misspelled in the caption. They say that is the predecessor in interest to the LLC entity, which is the landlord per the lease, and that's why there is no privity between the landlord per the lease and the Gap. Thank you.
Thank you. W54-7 versus Rooney.
They each have a minute more.
Oh, I'm sorry.
Cross appeals.
My apologies.
I'll be 30 seconds.
Go ahead.
Okay, 30 seconds. So Shabansky, we don't have to wait for Shabansky to put in a reply. As moving to summary judgment, they never address the issue, the testimony with regard to what was seen on the ceiling. That's with regard to Shabansky. In terms of out of possession landlord, they have a common law duty for reasonable inspection. They can't just say, I'm out of possession. With regard to res ipsa, as you know, number two, the second element, you could have a shared control is sufficient under res ipsa. So for my purposes, for it being a respondent, trial court properly applied res ipsa, and notice is inferred when res ipsa is applicable.
So if you have a res ipsa claim here, you're in the case, right?
I am, but the way our position is that our common law negligence case was dismissed. Negligence is out because the trial court, so we wouldn't have a negligence charge to the jury because the defendants got summary judgment on the issue of creation and notice. All we have is an inference of negligence at trial. So that's our position, and you know why we're taking this appeal with respect to that, because we're harmed for that reason. Okay, no further questions. I'll rest on my brief. Thank you very much. Thank you.
Thank you. Okay, W54-7 versus Rooney.
May it please the court, Richard Feldman for the appellant Eugene Rooney. Oh, I'm sorry. In deciding the motion for summary judgment, the lower court erred by deciding a disputed issue of fact when it determined that the landlord did not assume the obligation to obtain the public assembly permit. The evidence was conflicting insofar as we have the testimony of George Reichard, the landlord's architect, that he was hired by the landlord to file and obtain the completion inspections and certificates from the
But we
Department
have a
of
writing here that dictates the arrangement between the parties, right? And in that writing, your client assumed the responsibility for the C of O. They were put on notice that there was a C of O problem with the additional store, right?
It was not a C of O problem. Store lease for store number, there was an existing Irish pub in store number 2 from 1995
Yes, I know.
to 2009. In 2009, the parties agreed to rent store number 3, the adjoining store, and to connect it. There was no C of O problem, and to connect it and to amend the C of O and legalize the place. And the landlord agreed to cooperate by signing the documents. The commercial tenant agreed to do the work.
I'm sorry, counsel, but as my colleague pointed out, the lease for store number 3 put the burden on you.
Without a doubt.
Okay.
However,
So apparently, he only agrees when you say it, not when I say it. Go ahead. We love that.
no, I took from your comment.
We just love that. You continue.
Okay. And the landlord did the physical work, or the tenant did the work to open up the space and connect the stores and double the space, double the rent. And its architect, Paul Gregory, filed the papers, all 2s, to obtain the C of O and the public assembly permit. And then it was stopped by the landlord in November of 2010.
So are you asserting that there was an oral modification to
That's
the
exactly
agreement?
what we were.
Well, but doesn't the contract say that there are to be no oral modifications?
Yes, but there's case law that those provisions can be waived by the conduct of the parties. Here, there's no dispute, and they do not dispute, that the landlord hired George Reichard to complete and obtain the public assembly permit. George Reichard was deposed. He said, I was hired by the landlord. I took over this responsibility. I filed the forms.
So you're saying that there's something in the record wherein your adversary essentially concedes that they hired someone to take over what was your client's responsibility.
The actual architect testified at his deposition.
We got that. We heard that 3 times.
And
the question is, are you asserting that the landlord affirmatively took over the obligation that the lease says is your client's obligation?
The landlord did not deny that it undertook that obligation. Did not deny. In the face of Mr. Rooney's affidavit that the landlord undertook it, in the face of the undisputed testimony by the landlord's architect, he was hired to and did undertake it. There is no contradictory evidence that they did not.
Anyway, this is a claim for rent going after the guarantor, your client, Mr. Rooney, correct?
Correct.
Okay, and one of the claims you're raising here is that they've been constructively evicted as a defense.
Right, they basically frustrated the purpose of renting the second store.
Fair enough. But it's not disputed that from 2009 and for the next 10 years, you were operating the combined pub without an assembly permit, correct?
That's correct.
So
I'm sorry, my fault.
So you weren't constructively evicted, correct? I mean, constructively eviction based on the case law under Barish and his progeny is you didn't have access to your property. You did. You were there functioning, correct?
On January 4th, 2020, they received a criminal violation from the New York City Fire Department saying you can't operate this combined store without a valid public assembly permit. They left 3 days later because they could not obtain that because they needed the landlord's cooperation and the landlord had rested the obligation.
Does the contract preclude you from raising constructive eviction as a defense?
I'm sorry.
Does a contract preclude you from raising constructive eviction as a
In the event of a casualty, that's what Real Property Law 227 says, and that's when there's destruction by fire or flood or whatever, that the parties can contract out constructive eviction, because most leases say if there's 30%, the landlord has an option to repair, or 50%, so it gives the landlord an out to contract out of constructive eviction. But in this case, we're faced with a willful breach of the obligation by the landlord, which affects the public's health and safety, because public assembly permits are necessary, reminding of Happy Land.
Apparently not, because your client operated this business for 10 years without one. But we will hear you on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Cornelius P. McCarthy of the firm Chayabard, Devaney and Phillips for the plaintiff respondent W547 LLC. This is a suit on 2 guarantees, and we think a relatively simple case.
Did your client take over and assume the responsibility that was clearly stated in the lease for store number 3?
No.
And what evidence in the record is there that that is the case?
The evidence in the record, first of all, there's documentary evidence in the record that that's the case. If you look at the document that Mr. Rykar signed, the document just is what is known as a post-approval amendment. All that post-approval amendment allowed the tenant to do is, in effect, piggyback on the change in use application, the generic change in use application that existed for the building as a whole. In other words, there was in building department lingo, that's known as an Alt-1. That's what that application is known as. If you want to do, or if you want to, if you have a change in use and occupancy, you have to base it on an Alt-1. They decided their Alt-1, their initial application, was rejected. After it was rejected, we said you could piggyback on ours. All the documentary record says is that, from his client, is that we're going to withdraw our Alt-1 because it's a duplication of the Alt-1 that already exists. In other words, it's a duplication of the Alt-1 that the building has as a generic matter. And all Mr. Rykar says in his post-approval amendment is that we're just amending the Alt-1 so as to change the use and occupancy on the first floor to a bar and grill, and to change the use and occupancy in the basement to an accessory kitchen. So he didn't take over the whole project of acquiring a public assembly permit at all. He didn't take over the project, if you want to call it that, of obtaining a certificate of occupancy on the pub. After an Alt-1 is filed, a whole series of things had to have been done to, in fact, set up the application for a certificate of occupancy, and then following that, they had to file for a public assembly permit. So, number one, they had to do all of the work to actually combine the premises. That was all done pursuant to their applications. Number two, they had to create plans, architectural plans that had to be filed. That was done by their architect. Number three, they had to install, because their Alt-1 had been rejected, in fact, ours was too, they had to install sprinklers. Number four, they had to get the installation of the sprinklers approved. That wasn't done until April of 2018.
Counsel, can you speak to the constructive eviction claim regarding the fire department giving them a criminal summons, and whether, in fact, the lease precludes them from using that as a defense?
Well, the lease does preclude them from using that as a defense, and the waiver of constructive eviction comes in two places. It comes in, I believe, paragraph 9 of the form lease, and that does refer to casualty events, which is standard in the real estate board form. But it also comes in the rider, and the court below pointed out that in paragraph 6 of section 40 of the rider, whenever in the lease the term without liability is used, that meant, among other things, that there had been and there was a waiver of constructive eviction as a defense. In addition, when the fire department actually issued the summons in January of 2020, that summons did not evict that tenant or force that tenant to vacate in any manner, shape, or form. These premises were legal when they were leased. That is the consideration that his client, the bar, obtained. That consideration was never impaired. They had an option, if they wanted, to put more people in the bar, as is the case with every other bar in New York City, to go and get a public assembly permit. But they had to do that, not us. And critically, the absence of a PA permit did not render those premises illegal at all.
Thank you. You have 1 minute on rebuttal.
Thank you. So, as Your Honor pointed out, cases go back to Barash versus Penn Terminal Real Estate that say a commercial tenant can be constructively evicted if the landlord permits or causes a condition that affects health and safety. A public assembly permit goes to that very issue of public health and safety.
I'm sorry, why did the absence of a permit affect health and safety? It affected their use of the premises, not...
Which goes to the public's health and safety in terms of means of ingress and egress. Happy Land was a fire in a...
We know.
Okay, let's not
We're
do
from
that.
the Bronx.
Yeah.
Okay, so you know. And
But you could have continued using it with just the one store, right? Like with the certain amount of people that didn't require you to have a public assembly.
Again, they had a 14-year successful operation in store 2. They rented store 3 solely for the purpose of doubling the space, doubling the rent, and connecting them and getting a public assembly permit. And by not getting it, where here the council has admitted
But now you're saying it's an economic issue, not a health and safety issue.
well, no, it became it was a health and safety because of the absence of the PA permit. And the fire department ultimately came in and issued a criminal violation.
Thank you.
Here, may I just say one more thing, Your Honor? Okay. Council said there was a piggybacking. That's an express acknowledgement that the landlord undertook the obligation. That's exactly what happened. And whether it's construed in one way or the other is a fact issue.
Thank you. Board of Managers of the Lenox Court Condominium versus Owen Curtin.
Good afternoon, Your Honors.
Good afternoon.
Owen Curtin, defendant, appellants, pro se. May it please the court. This is an action for a RPL 339 AA board lien foreclosure of a condominium.
Was there a home loan here at all?
There is a home loan. It's just not at issue. It's not in the record either. But we believe that the lender, which is a refi lender, is separately represented on an undisclosed basis by the same law firm that is representing the Board of Managers. As I said, it's not in the record, so I wouldn't want to take that up.
Why don't we not talk about what's not in the record, counsel?
I'm sorry.
Why don't we not talk about what's not in the record?
I apologize, Your Honor. I was just...
No, but let's understand it. Rent was owed, correct?
I'm sorry?
Rent was owed.
Common charges.
Rent, common charges.
Yeah.
It's a synonym. So when you owed rent and there's a certain amount, then the condo put a lien on this apartment and sought to foreclose on the lien. There was no loan here, correct?
Correct.
So therefore, the notice requirement that you're resting on to get this case dismissed is not implicated at all.
Well, Your Honor, I don't believe that that's the case, and I can explain why in one sentence. That is the position of a respondent, but the Section 1304, the 90-day notice provision of the RPAPL, which has been imported into the lien foreclosure proceeding under RPL 339AA, says that the people who have to give notice are a lender, an assignee, or a mortgage servicer. And I believe that the reason for
None
that,
of which the landlord is.
the Board of Managers, Your Honor.
The Board of Managers.
But Your Honor, the reason
Explain to me how they fall under that definition.
I'm about to try to do so.
Okay.
And I only need a sentence or two to do it. With respect, the reason for that, Your Honor, is that I believe that the legislature, in enacting RPAPL 1304, didn't want, for example, a mortgage servicer to attempt a foreclosure, not give the 90-day notice, and say, well, I didn't have to give the 90-day notice because I'm a mortgage service, because I'm a servicer, not a lender. Now, and that's true in the case of a mortgage, the ordinary case for RPAPL 1304 application. But then the legislature also imported, and this court has ruled in the Alaska Seaboard case, all of Article 13 of the RPAPL into RPL 339AA.
Oh, no.
And we
No.
have not been able to find a single exception to that rule. You know, the legislature could have enacted a separate, nearly identical version of Article 13 into the Condo Act. It chose not to do so, and frankly, many provisions of Article 13 have internal references to mortgage foreclosures, including 1311, the provision that this court construed in the Alaska Seaboard case in 2007. There's a reference to mortgage foreclosures in subsection 4 of that section. So by the logic of respondent, which I understand but don't agree with, the importation of Article 13, which the legislature stated and which this court has affirmed, is a kind of nullity, because any provision of Article 13 that facially refers to mortgage foreclosure procedure should not be considered.
Common charges haven't been paid here since 2020, right?
Oh, no, Your Honor. I've been steadily paying back the common charges all along.
Oh,
In fact, that's not part of the record, because this relates to an appeal of a denial of a motion to dismiss at the very outset of this action. But basically, these are common charges that arose during the pandemic and moratorium, and we had some cash flow difficulties, and since then, including up to the last couple of months, we have been steadily repaying common charges and mean to conclude doing so by the end of the year.
You'll have time on rebuttal. You're out of time. Thank you. You may proceed.
Thank you, Your Honors. Magda Cruz for the condominium. Your Honors, in this lien foreclosure case, there was no failure to serve a predicate notice. The law does not require it. Simple as that. And it's very clear that my adversary is here conflating the words in Real Property Law 339AA, which says that a condo lien for common charges may be foreclosed by a condo board, quote, in like manner as a mortgage of real property. It doesn't say exactly the same. It doesn't say precisely everything is imported. It simply provided a framework for condominium lien foreclosure actions, which are different from mortgage foreclosure. I mean, I don't want to belabor this, and the lower court properly denied the motion to dismiss because it had no legal basis. And for that reason, I would respectfully ask the court to affirm. Thank you.
Thank you. Counsel, you have a minute on rebuttal.
Thank you, Your Honor. Just a quick point in response to what Ms. Cruz said. The legislature, as I said, chose to import wholesale Article 13, and they have to be
If
assumed
we
to...
disagree with you on that,
Well,
then you lose, right? Right?
You lose if there are exceptions that can be chosen.
So you're saying that that phrase imports the entire article into that one section. If we disagree with that, then your argument falls.
Well, not exactly, Your Honor. In the Alaska Seaboard case, this court said...
The Alaska Seaboard case did not involve this section.
It was a different
So it
section,
is-
but it was a section that involved mortgage foreclosures. In fact, Your Honor, and that's...
But this
is
isn't
the
a
thing-
mortgage foreclosure.
That is the thing that I
And
wanted...
this is what you keep on likening it, but it's not the same. But we have your brief and your arguments. Thank you.
Your Honor, may I just say one
Thank
sentence?
you, sir. DM Hospitality versus Sahara Plaza. You have 5 minutes.
Good afternoon, Your Honors, and may it please the court. John Malieri for 2M Hospitality, the appellant. The trial court here erred by ruling that the restaurant Ora de Pasta didn't state a claim for money damages.
Well, how could you state a claim for money damages if Article 63 pretty much controls the remedies you can have here?
Because the case falls within the exception first set out by Kalish Jarko and again adopted many times, for example, in Solo, that intentional misconduct can't be exculpated. That's really the essence of the claim.
How is this appeal not foreclosed by this court's decision this year in Olma Serve 21 Group versus Sahara Plaza?
Well, first of all, there's nothing in this record that says that the lease in Olma is the same as the lease here. There's just nothing in the record that says that. But secondly, even if there were, that case was on summary judgment. This is about whether we stated a claim. This is a motion to dismiss. And also, that case, the ruling says that it relies...
We got 2 people from that case, so I would be careful if I were
Your Honor, I'll rely on the words on the page. Because
Okay,
that's
good.
all I'm able to do, and it says that the tenant below raised an argument about authority and raised an argument about mutuality of obligation. The issue of intentional misconduct, the Solo argument, that simply wasn't made in that case. So it's a novel issue. The question here is our case properly pleaded to say that we fall within the exception established by Kalish Jarko and Solo and all of these other cases, that there's thousands of progeny of those cases about when the exception to an exculpation clause applies. And our case is really very much like Solo. We pleaded that there was intentional misconduct that was only intended to serve the landlord's interest. The question is not whether we win. The question is whether we pleaded it. Is it properly pleaded? Can we proceed with our case? And in Solo, this court said that the defendant's not required to anticipate all of the arguments, and there's no reason for the complaint to allege.
When Sahara Plaza refused to allow your client and other restaurateurs who operated within the lobby to come back and open up their businesses, was there no thought to go to court in order to force the issue, since the lease said that's your only remedy?
Your Honor, we already prevailed in a separate action that I think the court has we've won the liability on summary judgment and received an order and judgment for specific performance. The question here is, were we lulled into waiting 2 years after the COVID orders were issued? Were we lulled by the landlord's conduct to waiting to seek that other remedy? During that period of time, it's the complaint we're here with. The complaint says They told us repeatedly they were going to reopen the food hall. They lulled us into the idea that the food hall would reopen. Once they definitively said, we will not reopen the food hall, we took legal action. We brought this case for money damages. It was dismissed and we're on appeal.
How does that pleading allege an intentional wrongdoing for their financial benefit? Just lulling you into this false sense.
The lulling is why we waited, Your Honor, but the question of whether we properly pleaded willful misconduct, I think we argue that's in paragraphs 1, 4, and 5, especially of our complaint. The most important one is probably Sahara Plaza shuttered the food hall to serve its own interests. The lesson from Solo, this court says, you don't have to use any particular words. You certainly do not have to plead the word with malice or with willful misconduct.
Well, to serve its own interest, but you do have to plead that there was some sort of financial interest that it was gaining, and you didn't plead that. You just said to serve its own interest.
I think it's the opposite. I think they argue that we can't plead pure economic self-interest, and what we plead is they had a scheme to recover the food hall and deprive us of the right to use our leased space. And again, by the way, we won. We've already won on this issue. Liability has been determined by the Supreme Court, the same judge, in another case. The question now is, can we also seek money damages because the doctrine that's at issue in Solo, that they can't exculpate for themselves from their own willful misconduct, can we proceed on that? Not whether we win on it. Can we proceed? Can we discover whether they operated with willful misconduct?
Thank you.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. Max Rubin, Warshaw Burstein on behalf of the respondent. Page 95 of the record, Emma Skinner's affidavit, paragraph 11, compares the two leases between OMA and Ora Deposit. It's the same exact lease. As the court is aware, same lease, same COVID-19, same reason that the food hall closed. Immediately, 20 of the 24 tenants surrendered their leases, so it wasn't as if everybody was clamoring to get back in. When they sued for money damages, Justice Ostrager, in the OMA case, said that lease Article 63 precluded any recovery of money damages. It's the same case. Lease Article 63 isn't an exculpatory provision, it's the sole remedy provision. It limits their sole remedy to specific performance, which they got. So that's basically where they are. They got their own remedy.
Just for my edification, they haven't paid any rent this whole time, correct?
No, not since March of 2020, and especially not since July of 2024 when they obtained specific performance. We offered to let them leave. We said, all right, you want to go? Go. They didn't. They got their remedy.
Okay. Thank you. You have 1 minute.
Thank you, Your Honor. The OMA case, first of all, the motion for summary judgment, the motion to dismiss has this other lease in it, but that's not properly before the court. The question is whether the complaint has properly pleaded willful misconduct. But again, the OMA case is different, and I'm sure the court will look at it because it only talks about these defenses about mutuality and authority.
Well, we're not restricted to just looking at what arguments were made on OLMA. If indeed the OLMA lease is exactly the same as this one, then again I ask you, how is this case then not foreclosed by that decision?
Because we've raised a new legal argument. We have our own lease. We're not OLMA. I don't represent
I
OLMA.
understand that,
We've got a new
obviously.
argument. Our complaint says that the landlord acted in its own self-interest and willfully prevented us from using the leased premises. There's no difference between a exculpatory clause and a sole remedy clause. That distinction is a false one. In fact, in Solo, the case that's calls it an exculpatory clause, the case there said it was a sole remedy. And this court has twice, even after putback, has twice said that the willful misconduct doctrine is still alive even after putback. Thank you.
Thank you. Canner versus Westchester Medical Group.
Good afternoon.
Good afternoon.
I am Sanford Stranger, and I represent the appellant, Dr. Barry Canner. It's clear that Dr. Canner was entitled to his default judgment. Judge below said so. He then said, however, and he said so because we established our prima facie case. We put forth our affidavit of service. We put forth an affidavit from Dr. Canner, which said these are my claims and the merits of my claims, and we also served additional notice. So, and the defendant didn't respond. Didn't respond within the original time they were supposed to respond, and then that was it. They're in default. Their focus as to attorney, that their attorney excuse took place after the original default. It was after we served our additional notice. What happened here? The judge below held that the attorney's affirmation, which included alleged arbitration agreements, was inadmissible as evidence. And
Why?
Excuse me?
Why?
It was inadmissible because it was submitted by a person without any knowledge. The attorney nowhere in her affirmation said that she's the record keeper, that it is a business record, that she is familiar with the documents. She could not get those documents into evidence in a court.
Counsel, this is the ultimate irony, because Dr. Canner is seeking monetary damages based on the very documents that have arbitration clauses.
Your Honor, yes.
So you didn't really challenge the authenticity of these documents.
We can establish, for purposes of a default judgment, I can, because with respect to that, Dr. Canner, on an inquest, would have to establish what his contractual rights are. However, the respondent, Westmed, can't rely on documents that was submitted. They have a duty here. Their duty was to come forth with admissible evidence of a meritorious defense. They did not. And the judge clearly held that, and then he veered from that. He said, however, there's these arbitration clauses. Now, no one in the record admitted that those are the actual arbitration clauses. Dr. Canner didn't say these are the agreements. He said there is an agreement. They didn't say, they attached a record which said was an admission agreement. That admission agreement did not, they said it incorporated the other agreements. It doesn't. It says, it mentions those agreements, and he says he has to independently sign those agreements. The admission agreement does not have an arbitration clause. And clearly, the difference here, and if I just move on, so if you say, well, if there's an arbitration clause, there isn't one arbitration clause, there are three. And those arbitration clauses send the parties to different arbitration
That
panels.
doesn't mean that it's not binding on your client.
Excuse me?
You acknowledge that there are arbitration clauses. The fact that they might call for multiple arbitrations doesn't relieve your client of the obligation to arbitrate.
Yes, it would if they were intertwined. Yes, it does, because
What
they are
relieves-
intertwined agreements. And
Your client signed that agreement, which had the multiple arbitration provisions in them.
he signed an admission agreement that had no arbitration agreement. He's then signed, he acknowledged the shareholders agreement.
Right, which
but in
had
order
another
to-
arbitration clause.
Which had an arbitration agreement. However, in order to arbitrate, to force a person to arbitrate, there has to be a clear intention to
And usually a signature on a piece of paper that says, I agree to arbitrate, satisfies that,
Your Honor,
counsel.
I would submit to you, you're right, it does. However, if you have an intertwined agreement and it's not clear where you have to go, and you can go to two different venues and get two
What case says that?
Well, Your Honor.
What case says what you just said, that if they're intertwined and they don't know, what case says that?
Your Honor, this is a unique case. This case would say that.
Ah, okay.
Because they are
So you have no
intertwined.
support for your argument, is that what
Excuse
you're? So there is no case law supporting the argument you just made?
And there's
Is
no
that
case
correct?
law supporting the other side, Your Honor, either.
Thank you.
Thank you.
It's saying that there is.
Thank you.
Good afternoon.
You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Katarina Catalano. I'm here from Jackson Lewis on behalf of Respondent Westmed. It's a very simple case. in his summons with notice, which is unverified, he references several times 3 agreements. It's the shareholder agreement, the employment agreement, and the income agreement. And all of them say in sum and substance, in the event that any controversy or claim arising out of this agreement cannot be settled by the parties, such controversy or claim shall be settled by arbitration.
And so what, from your point of view, what is the significance of the fact that 2 of the 3 agreements call for arbitration in different fora?
Nothing. He is a sophisticated party who signed the agreement, those agreements in several different locations. He
So
consented.
it just means that there should be arbitrations in 2 different fora?
Well, or we could, work that out in arbitration. It's not a different forum, and it's also the same geographical location.
Nothing would prohibit the parties from agreeing to arbitrate in 1 location as opposed to 2.
No, Your Honor. And as we go towards the default, the affidavit from Nicole Klug shows that once she returned from bereavement leave and she got that notice of service from appellant's counsel, once she returned, she promptly forwarded that to outside counsel. Outside counsel and counsel for appellant engaged in numerous discussions attempting to resolve this, and both were very clear on their positions. Appellant counsel was clear that he believed that Westmed was already in default, and Westmed's counsel was very clear that they believed that there were valid arbitration agreements. And once a resolution was not able to be reached, that's where we are today. And we do believe, to the extent that the lower court mentions any form error, we don't believe that that was enough to, as the court also found, to invalidate these 3 separate arbitration provisions that call for the same thing in this case.
Thank you. You have 1 minute.
Thank you, Your Honor. What wasn't mentioned, Your Honor, which in my argument going forward, is that this case was dismissed by the judge below, or completely. The appropriate remedy should have been staying the case, not dismissal. And there's 1 case that was cited, Your Honor, the Republic mortgage case, Your Honor. It was a case from this court. It did not, from the appellate division level, did not address that issue. It merely affirmed the lower court's dismissal of the case, but it focused, the entire appellate division decision focused completely upon the other issue. There's a Court of Appeals decision that was mentioned by the judge below. If you would hold in this case that dismissal is appropriate, then you'd go contrary to the Court of Appeals, and you'd go contrary to the Second Department. And you'd be creating a new rule in this department that would set this up to have to go back potentially to the Court of Appeals, which has already ruled on that issue in the independent builders case.
All right, we'll take a look at that. Thank you.
Thank you, Your Honor.
All right. A&A Management versus Kassadov.
Good afternoon, Your Honors.
Good afternoon.
Daniel Sully for the appellant plaintiff, if it please the court. A summons and complaint was filed in this case alleging unjust enrichment and conversion as to the defendant, respondent, Gerell. The complaint was served through the Secretary of State. An inquest was held on this. In the inquest order by Judge Miles, the judge recited specific pieces of evidence that he had considered, including pictures and lists of equipment and other evidence. No order was issued based on that.
You knew that the defendant had no obligations under the contract, right? Because it was not a party to the contract.
I'm sorry?
Would you agree that defendant
Yes,
Gerell,
not a party to the contract.
but part of the judgment against it at inquest was under the contract, right?
Part of the judgment, the money award, was crossed over to.
So you
take
would
into
agree
account-
that part should be vacated?
I believe that in fairness, it probably should be reconsidered as far as the amount of the inquest award. I do not believe it should be sent back to square one. As I was starting to say, Judge Miles did, there was a legitimate summons and complaint, made allegations of unjust enrichment and conversion. The defendant did not answer the complaint. An inquest was held. Judge Miles found specifically stated, defendant Gerell is currently in possession of plaintiff's equipment and is refused.
But what evidence in the record was there of that?
Of what, Your Honor?
What evidence was there in the record that Gerell was in possession of the equipment?
Well, I wasn't at the inquest, Your Honor, and nobody has.
Well, I would imagine that if you have filed an appeal on that inquest, that you have taken the time to review the record of that
Well,
inquest.
what is in the record is the judge's order, which is what Judge Ramirez based her decision on, and it says the inquest, the court looked at pictures of the radiology center where the equipment was housed. The court looked at the lease, which stated the premises was to be used for medical imaging. The judge recited that he looked at pictures and pricing of the equipment in question, and there was obviously testimony. So there was evidence presented at the inquest.
So the photographs of the equipment, were those photographs of the equipment, did they have dates of when
I haven't seen the photographs.
when those photographs were taken?
I have not seen them, Your Honor.
And where those photographs were taken?
I have not seen them. I'm working with the same thing that Judge Ramirez worked with, which was the order of Judge Miles, and that order stated what I just stated to you. So I don't know if they were time-stamped or what have you. The plaintiff would have been present at that inquest. Judge Ramirez made her order without looking at the inquest. She made it without considering 50-15. She did it on the interest
You
of.
said she looked at the same inquest, the same order that you're looking at from the inquest, right?
Correct. Judge Miles' decision on the inquest was what Judge Ramirez looked at in vacating this judgment. She did not look at the inquest transcript.
Did you?
I have not. It's not part of the record.
So, counsel, I have another question about the inquest. Another element of it was for punitive damages, but you didn't sue defendant Gerell for punitive damages, correct?
I believe it was sued for punitive damages. The summons and complaint, I do believe, requested punitive damages.
Yeah, but that was against the Kassadov defendants as well. It's a multi-party defendant here. You have the Kassadov defendant and YBX, and you threw in Gerell Realty, correct?
Gerell was not just thrown in. Gerell was made a party to the action.
No, I understand it. I mean, forgive me for being colloquial. I didn't mean any disrespect.
Yes, so they were named as a defendant.
So the
and
punitive damage claim was
damages
against.
were sought against everybody.
Was against everybody.
Yes, I believe that it asked for at least $1 million in punitive against the defendants.
And on this record, you're aware that there's a current tenant, Wellness Diagnostics, is actually using this equipment.
Our
right?
belief to this day is that that equipment is in the building.
So if it's in the building and there's a tenant who's using it in possession of the space with the equipment, then where was the basis for finding that Gerell is in possession of the equipment?
Gerell, well, the first tenant left, and Gerell then accepted different tenants. So
Right.
at that point, when the first tenant left, Gerell's got the premises, they've got the equipment, and they're renting the space out based on the fact that it has built-in, very expensive medical imaging equipment that they're presumably charging rent for to this day. And not only did the order from Judge Ramirez vacate the money aspect of things, it vacated our right to replevy. And so now we can't even go get our own equipment back. And again, to this day, you can look online. I know it's not part of the record, but I mean, it's consistently being rented out to medical imaging companies.
All right. We'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Raymond Cohen, the Cohen Law Firm, attorney for the respondent. I think Your Honors hit the point home.
Well, does your client have possession of this?
No, Your Honor.
So it's not in the building?
We have no idea if it's in the building or
What do
not.
you mean you have no idea?
I'll
An MRI machine is not like a cup, okay, that you can hide it.
Your Honor, that may or may not be the case, but what counsel left out was that there was an initial lease back in 2009. The lease was assigned from one party to the other. My client never took possession of the space. My client never had use of the equipment, never took possession of the equipment, didn't know or care what was inside the space. And for all we know, Wellness, the tenant that is there now, brought in their own equipment. This is not something for my client to determine, and it's certainly not something for my client to be liable for.
Counsel, why didn't your client allow them to look into the wellness area when they went to look at the other facilities area to see whether the equipment was there?
Your Honor, my client never had an issue with counsel or plaintiff entering the building to go and search for
That's not what the record says.
No, that is what the record says, Your Honor, because what happened was when they were making a motion to access the building, they were making a motion to access a different part of the building. I appeared in front of the judge, in front of Judge Ramirez, and I said, Judge, I don't care if they go into the correct space, but they're not asking to go into the correct space. And they were going to...
How many MRI diagnostic companies does your client have in that building? Answer my question.
I believe there's one diagnostic place, but there was also another tenant that had a medical name to it. And they were attempting to get into another...
Urban
space.
Health. It was Urban Health.
Urban Health. Thank you, Your Honor.
Okay, so look. Again, MRI equipment is big. Really, really big. It usually occupies an entire room, right?
Yes.
So I'm trying to understand if your client has absolutely clean hands, what's the problem with letting them come in and look?
Your Honor, I actually called counsel after that hearing when they were seeking to get into the building. I had no issue with allowing them to go in. In fact, Your Honor, why do they even need a court order? It's a public arena. They can make an appointment and say, I need an MRI and walk in themselves.
Yeah, but they can't. They can walk into the ante room, but they can't walk into the room where the MRI machine is.
Your Honor, the fact of the matter is, Your Honor, the entire Judge Miles' decision had absolutely no common sense to it. It had no basis for it. They obtained somehow a $3.6 million judgment against my client, a landlord, when my client had no possession, no ownership, no interest in any of the parties, wasn't even a party to any of the leases, wasn't a party to any of the contracts that went on between the parties that were dealing with the medical equipment. My client just simply allowed the lease to be assigned from one to the other.
Counsel, let's talk about the default. I'm sorry.
Yes, Your Honor.
So there's no question that your client knew about this lawsuit in August of 2022.
Yes.
Why did it take more than a year before it moved to vacate?
So there was a bunch of...
Or actually, let me ask you a different way. What in the record shows why it took more than a year to move to vacate?
Well, first, keep in mind, Your Honor, when we were in front of Judge Ramirez on their motion to try to seek entry into the building, I had made the application in front of Judge Ramirez.
Orally, but that's not the same as a
Or
motion.
orally, yes, correct, Your Honor. So
we all know that an oral motion is a nice thing to do. It's sort of a placeholder, but it doesn't serve the function of a written motion on notice.
Yes, Your Honor, I have to...
Why did that not occur for more than a year?
There was
You're certainly aware of the requirement that a motion to vacate be made within a year of your discovery of the default, right?
Yes, Your Honor, but
So what's the reason?
The real reason, it was sort of shock and awe by my client. He could not believe that he had to lay out $20,000 or $30,000.
I'm sorry, I don't recall that. I've never seen a case that justifies a default in moving to vacate based on shock and awe because the lawyer's so surprised that they're being served.
Well, counsel, did it have anything to do with Judge Ramirez saying on the record that you guys should stipulate to vacate the default?
Well, that was part of it. I would have responded to Your Honors. But in addition to the shock and awe factor and the money that my client would have had to have laid out, it was also where Judge Ramirez actually urged the other side to vacate the judgment voluntarily. I had called counsel several times. We were in talks to try for them to agree to vacate.
And I get it, okay? But once you see it's not happening, that time clock is ticking. You know what your obligation is.
You're absolutely right, Your Honor. I want to add one more thing, if you would allow. There's an entire body of case law that says that a court has the inherent power on its own determination to vacate a judgment in the interest of justice. And that's exactly what we had here. I think, in my opinion, the real question should be, why did they sue my client, who was just a landlord who had zero to do with the medical equipment? They sued my client for millions of dollars for equipment without any basis for what the equipment is worth. And they can go in today and see what the story is with the equipment. They somehow obtained a $3.6 million judgment, and $1.6 million of that judgment was punitive damages against my client, who never even received the papers to begin with. It didn't make any sense.
Part of the reason didn't receive the papers is because of the issue with the address left with the Secretary of State?
Yes. So there was that is true, Your Honor. However, I would like to point out, and it's actually in the record.
I saw the record, but that doesn't actually require that service be made on that entity as opposed to the other one.
Well, Your Honor,
It's a different name for a registered agent.
No, Your Honor. Actually, if Your Honor looks at the document that my client filed with the state, it asks to change.
Permissive service on the registered agent, but it doesn't change the agent for service of process.
Well, Your Honor, I don't know exactly why the.
All right, we don't have to debate this. Thank you for your argument. Counsel, you have time on rebuttal.
Thank you, Your Honors. Your Honors, as far as you hit on some good points. Back in the September 22 meetings on the hearing when we were trying to enforce the replevin, Judge Ramirez says in her decision that she told us that the judgment should have been vacated. She tried to broker a deal. We specifically said, let us get into the building and show us that there is no equipment there, and we have really nothing to go further on. And it would certainly give them a very big leg up on vacating the judgment if they did let us go in there and we were unable to find any equipment. As far as going in and making an appointment to go get an MRI, yeah, there's going to be an MRI.
What's your account of what happened when you went to the location to try to go in? What is your account of what occurred when you went to the location to try to get in to see what was there? Were you precluded from going?
Well, the sheriff did go with my colleague Michael Azen, who is co-attorney on this with me, who is also sanctioned himself, as well as me, which I would like to touch on. Judge Ramirez sanctioned us for basically not vacating our own judgment. But to your point, the sheriff did, in between the first and second hearing, as I recall, the sheriff went to the location, searched just the universal health care, whatever it was.
Urban health.
Urban health, and just that one section of the building, a whole big section of the building that wasn't searched. We couldn't do it on our own because we would have to look at the social security, the serial numbers on the equipment. You can't just look at an MRI machine and say, that's mine. As you said,
why didn't the sheriff search the other parts of the location?
Instead of the imaging place.
Excuse me?
Why would the sheriff search the urban medical center as opposed to the imaging place when what they were looking for was an MRI machine?
The other place, from what I understand, is the other building was locked up. It was under lock and key, which kind of is contrary to what Mr. Cohen's saying about there being a steady flow of tenants there. But only urban health was accessible.
All right, I'm going to give you, you're out of time, so I'm going to give you 30 seconds to address the sanctions.
As far as the sanctions go, we basically got sanctioned. This judgment was vacated not on the CPLR. This judgment was, which was the first time they put in papers, was the motion to vacate. That's the only papers they put in, a year late, and all we did was oppose those papers. Okay, when Judge Ramirez was saying that she thought the judgment should be vacated, she said that without having looked at one piece of paper, without one sworn statement from the defendant. All we did was oppose the motion to vacate, and we were sanctioned for doing that. Or it's also not entirely clear. Maybe we were sanctioned because we didn't vacate our own judgment. I'm still to this day not entirely clear on why we were sanctioned, and there was no hearing for the sanctions.
So you'd like us to vacate that sanction, right?
Absolutely, and the attorney fees and the order vacating the judgment. Thank you for your time, Your Honor.
All right, People versus Tyrone Gines. You may proceed.
Good afternoon, Your Honors. Isabel Patkovsky on behalf of the Legal Aid Society for Mr. Tyrone Gines. After Mr. Gines conceded that he left treatment, the court decided to hold a hearing to determine the appropriate sanction, but it then embarked on an analysis that thoroughly failed to comport with due process. Accordingly, Mr. Gines's conviction should be vacated. Your Honors, what is so, I think, unique about this case is that there was no question that Mr. Gines left treatment before the Outley hearing occurred. That was not the dispute of the hearing. But the court, in its discretion, ordered further inquiry. The court said, I'm not sure if the appropriate sanction for Mr. Gines leaving treatment is to terminate treatment, so I'm going to have an inquiry. And because the court made that decision, it had to comply with due process. It couldn't proverbially just flip a coin and say, that's how I'm going to decide whether to terminate or not. And our argument is that this hearing that the court held was closer to that proverbial coin flip than it was to a fulsome hearing under the law.
How? When defense counsel was given an opportunity to raise arguments and to put in whatever evidence that the defense counsel felt bore on the matter.
And defense counsel did.
Well, so then what's the problem?
The problem, Your Honor, is that the court's decision relied on evidence that had absolutely no basis whatsoever. The court avowedly applied—
Like what?
For example, irrelevant and completely unsupported allegations about Mr. Gines doing something in the court pens that there was no witness to. There was no proof other than this say-so. The court specifically said—
Are you suggesting that the court did not have ample basis to do what it did just based on your client's failure to complete the program and walk out?
No, Your Honor. That's not what we're saying.
Isn't that the purpose of an Outley hearing? Is just to determine whether there's been a violation of the conditions.
In this case, that was not the court's stated purpose for having the hearing.
It doesn't matter what the court stated. That's the purpose of an Outley hearing, right? And that was admitted by the defendant. It was admitted by the defense attorney, and there was a letter in the record from the director of the program saying that the defendant left the program without authorization. And P.S. he can't come back because he violated other conditions, which we won't take him back. That's it. End of story. It's a violation.
And he didn't return back to court on his own volition, but instead was rearrested and brought back in involuntarily.
That's correct, Your Honor. I think there's two things going on here. The first is the questions of whether that evidence, for example, was an appropriate basis for terminating probation, for terminating diversion. The other point to your question—
They had to have consent for him to go into this program.
Correct.
Okay? He wasn't even eligible as of right. And the DAs bent over backwards to get him into the program, and within 1 week, he messed up and left.
Mr. Gines was born with an opioid dependency. He has been dependent on substances for 36 years, his entire life. And CPL 216.05 explicitly recognizes, it says, that people who successfully complete drug treatment, if they have a serious substance
Counsel, we understand that relapse is a part of kicking an addiction. That's understood.
Yes.
He didn't come back.
He actually
come back.
did say on the record that he went back to treatment and they wouldn't—
No, he didn't come back to court.
Oh, yes.
You can't pick your own treatment. This is the program he had to complete.
No, he said he went back to this treatment. But I agree with you, it was a little confusing what actually happened.
All right, you have a minute on rebuttal. You have 2 minutes on rebuttal. Okay? Proceed.
Good afternoon, Jamie Maston for the People. The defendant actually said in his letter that he submitted to the court, I made a huge mistake by walking out. I was too embarrassed to return. So the answer there is that he did not return to the program that he agreed to complete. I would like to rest on I'm happy to answer questions about the waiver or preservation.
But the waiver, is there any argument that the waiver is valid?
I appreciate the concern there. I think that, yes. that, yes,
That's being kind.
I fully appreciate that. I agree. Oral colloquy could have been clearer. I think that it is defensible if your honors were willing to look at the totality of the circumstances, the fact that the oral colloquy was supplemented by a written waiver that spelled out the specific rights that are forfeited versus waived, the fact that he had counsel throughout this plea, the fact that he confirmed to the court that he discussed it with counsel prior to signing the waiver, and the fact that this was such a good plea for him. He had the chance to get his conviction dismissed. He only had to complete treatment. And everyone in that courtroom was championing him to do exactly that. They were wholeheartedly encouraging him to do so. So he went into this plea with his eyes wide open, knowing fully well what he had to do, and he simply didn't do it. And there was no dispute about the fact that he did not do it. The defense counsel below very quickly said the defendant had no legal right to walk out of the program. That's it. No further inquiry needed to be done because by the terms of the plea agreement itself, it literally said if defendant leaves the program without permission, the court will find that the defendant has violated the plea agreement. And the court fairly held the defendant to the exact plea agreement that he signed, again with his eyes wide open, and sentenced him to the minimum of 2 to 4. There is no reason for this court to disturb that conviction, unless there are any further questions.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Thank you.
Counsel, let me just ask you about your remedy. You're asking us to reverse and dismiss the indictment. That's not an appropriate remedy here. Wouldn't the appropriate remedy be reverse and remand for sentencing?
Well, at this point, Mr. Hernandez has already fully completed his sentence. He did 2 to 4 years. So there's really no situation in which he can go back into diversion on this case. It's just not an option. It is a felony. That's usually not the appropriate remedy. I would submit in this case where it was essentially a shoplifting of admittedly some high-price items from big box stores like Macy's, that it is still in line.
Well,
with the
I don't think it was Macy's.
It was Macy's and Saks.
It was Saks.
Saks and Lord & Taylor.
Yeah. If I may try my analogy one more time, the point that I'm trying to make here is, for example, in a sentencing context, if a judge were to sentence someone within the sentencing range, there's no question that that's a legally valid sentence. It's above the minimum, below the maximum. And there's no question here that it was an option to terminate treatment. If the court had decided to terminate treatment without a hearing, I actually don't know that I would have much of a leg to stand on. But once the court decides to have a hearing, our courts cannot just make decisions willy-nilly. They have to actually make decisions based on the factors that are in the law. And under the law, it was inappropriate for the court to apply a higher standard to Mr. Hernandez because he'd required the prosecution's permission to enter treatment. No court has ever said that's appropriate. The CPL certainly doesn't say that's appropriate. It was inappropriate to rely on a non-prosecuted rearrest. It was inappropriate to rely on the court's memory that there had been some kind of disturbance in the pens at some point. I presume the court was not in the pens, so the court was necessarily relying on someone else's description of what happened. And it was inappropriate to fail to weigh at all CPL 216.05, which does, as Your Honor recognized, say that relapse is unfortunately a very, very normal part of treatment and recovery. Thank you.
Thank you. And last but certainly not least, Herman versus Herman. You may proceed.
Thank you, Your Honor, and good afternoon. I know it's been a long one. May it please the court. I'm David Berger, Allegart, Berger, and Vogel, on behalf of appellant Mr. Herman. Your Honors, I will try to just make 2 points. The first really concerns the lower court's error in holding that respondents did not waive their right to the relief they sought by their contempt of motion, and relatedly, that the motion was not barred by the doctrine of laches.
I'm sorry?
And that the related point is that the court did not rule that the motion was barred by the doctrine of laches. Despite litigating with Mr. Herman for more than 4 years in 2 cases, in 2 different jurisdictions, 2 in Florida, 1 in Colorado, and never asserting once in any of those cases, either in a motion to dismiss or in answers, that leave to seek to bring claims against the trustee was required. They then, 4 years later, go to the lower court here and say, aha, there is this ruling. There is this ruling that says before Mr. Herman can assert claims, he must first seek leave of the court. They waived their ability to do so.
Why?
Because the law is clear, and the law of waiver is clear. It's a knowing relinquishment of a known right.
A court orders that before your client can file any action, he must receive leave of court. And you think that the other side can waive that requirement?
Absolutely, Your Honor.
Okay.
Absolutely. And the law is clear on that. The law is clear, and it's just as it is under the CPLR, it's clear under the law, the procedural rules of the other jurisdictions. In Colorado, under the federal court, Rule 12B, and
We have to follow the rules of other jurisdictions.
it is clear, and the case, I'll give you a case.
Is that what you're arguing?
I'm arguing, Your Honor, if you look at, for example, the case of Tang2 Intern Corp., 24 AD 3rd, 171 to 172, the court found waiver where the failure to assert that defense in a foreign court was not made. And the reason, Your Honor, is it results in serious prejudice. The prejudice is the respondents assert these claims, they litigate.
Here, it's not a failure to assert a defense, right?
I'm sorry, Your Honor?
This is not a failure to assert a defense. It's an enforcement of a court order.
No, the court order arguably says that leave is required. The question is how, or notice can be given.
No, that makes no sense. That makes absolutely no sense.
Respectfully, Your Honor.
0 cents.
Well, Your Honor, I see my red light is on. I would respectfully request that the court take notice in our briefing, and we analyze that very carefully.
Oh, trust me, we read it.
But the waiver argument is clear, as is laches. You cannot litigate.
All right, we've heard that. You'll have time on rebuttal. I'm not going to hear it again right now. You may proceed.
Good afternoon, Your Honors. Gail Gerson, on behalf of the plaintiffs' respondents. Your Honor, the lower court here did nothing more than enforce a 2013 court order which appointed Judge Belen as a temporary trustee of the plaintiff trusts, and it precluded the parties from asserting any claim against the trustee without obtaining prior leave of the court. The appellant does not dispute that this is a very common form of order, and in fact cites several cases that involve exactly that kind of order. It's worth pausing here for a moment just to explain how Judge Belen came to be.
Right, I was going to say that the import of this order rests with the backdrop of what brought us to this order, which was a conflict between the trustees before, right?
Correct, Your Honor. So the appellant is a judgment debtor against whom the court had entered a $100 million judgment in favor of the plaintiffs. That was in connection with a scheme to defraud his sister out of her 50% share of 2 trusts. And the way he did that was by installing his childhood friend as a trustee of those trusts. That trustee later provided a sworn affidavit setting forth all the details. The trustee resigned. The court appointed Judge Belen as temporary trustee. The whole point of appointing him was to protect and safeguard the rights of the trust and the trust beneficiary from the appellant. And so paragraph 11 of the 2013 order, which appellant claims to be surprised by, was intended to prevent exactly what has happened here. The proliferation of one frivolous action after another that has impeded the trustee's ability to collect any portion of this judgment. And it is ironic that appellant makes equitable arguments about the prejudice against him, that the plaintiffs have allowed him to spend tens of thousands of dollars litigating his frivolous claims. If only the plaintiffs had stopped him sooner, perhaps he wouldn't have wasted as much money. I don't think that argument stands up very well. I'll conclude just by saying that the court clearly acted within its authority to enforce a prior court order and to determine here that the actions that were commenced in violation of the 2013 order, because there was no leave granted, those actions did not warrant granting leave nunc-pro-tunc. Thank you.
Thank you. You have 1
If I
minute.
may, Your Honor. Very quickly, Your Honor, several points. First of all, the law is clear, and it's the Court of Appeals, as Honig v. Hannon, that you must raise those defenses in these other actions in order to preserve them. They can be waived. They were waived. What the respondents did was they litigated for 4 years until they got the result they wanted, summary judgment, and then came back. All of this
Saying that they
backdrop.
waived the provision about getting prior order of the court?
Yes. Yes, they did, Your Honor.
I understand, but where
Because
exactly, when exactly did they do that?
They waived them because nowhere in the other jurisdictions did they raise as a defense or move to dismiss, or in Florida move for summary judgment on the basis that the claim should never have been brought because of this order. Never raised it. They raised it in a footnote once, but didn't move on it, thereby showing they were aware of it. That is the knowing relinquishment of a known right. All
Thank
of
you.
the backdrop, that's not relevant. I'm going to get it. Thank you. Appreciate it.